but we must not deprive individual citizens of further liberty through the unfortunate passage of poor legislation. Kia ora tātou.
I call the Honourable Minister, Dr Wayne Mabb.
Mr Speaker, I'm going to open my remarks by noting that the bill proposed will not actually affect the parties in a Supreme Court case. They will, all of them, have the fruit of the result. But the Supreme Court decision raised wider questions which the bill has to deal with. One of the questions that's been raised in the House today is the issue of retrospectivity. The bill provides that video surveillance pursuant to a warrant on private property is lawful, both future surveillance but also previous surveillance. And to that extent, the bill negates the finding of the Supreme Court. For some commentators, and indeed some members of the House, such legislation, even if it were not retrospective, would in any event be wrong. However, the Supreme Court themselves has conceded that such surveillance would be legal provided it has specific statutory authority. They in essence invited this House to pass such legislation. And of course, any such legislation will always be subject to the Section 21 test of the Bill of Rights. In other words, such surveillance has to be reasonable. Presumably, therefore, what Mr Price and others are really concerned about is the fact that past surveillance will be deemed to be lawful. And that is actually the essence of the retrospective issue. There are essentially two questions here. Firstly, what is the legitimacy of retrospective legislation? In short, can any form of retrospective legislation have legal and moral legitimacy? Second, does this particular bill pass such a test? Is it a reasonable use of retrospective legislation? Now, for many people, it's axiomatic that all retrospective legislation is bad. And the reason is simple. Retrospective legislation typically makes something that was unlawful, that previously was lawful. But there are degrees of retrospective legislation, and this distinction is made by Burroughs and Carter in Statute Law of New Zealand at page 588. And they say this: in essence, retrospective legislation is only objectionable if it takes away existing rights or defences, makes unlawful things that were previously lawful, or attacks as attach or other liability to something done in the past. In short, people's rights, in respect of bad retrospective legislation, people's rights are being removed in a way that they could not have anticipated. That has been a common feature of tax law. People have legal arrangement, Parliament then passes law which makes such arrangements unlawful, and of course it's regarded as objectionable because people cannot change their circumstances. How could they do so? They would in fact have to be time travellers to unravel what they had done to make it lawful. One of the fundamental tests, therefore, of any law is that it has to be predictable and certain. And retrospective legislation, the bad kind, offends against that principle because citizens cannot know whether their currently lawful actions will be rendered unlawful ex post by legislation passed by a future Parliament. Now, ironically, in this case, it's the Supreme Court that has passed a retrospective decision. They have rendered unlawful what was previously considered by the courts, a number of courts in fact, to be lawful. The police use of surveillance was undertaken on the basis of Court of Appeal decisions in 1997, the Queen and Gardner and the Queen of Fraser. In both those Court of Appeal decisions, they had allowed video surveillance evidence because it was deemed not to be unlawful. So the intent of this bill is to essentially restore the status ante. It is to make lawful today what had been previously always considered to be lawful until the Supreme Court decision. So therefore it actually meets the test laid down by Burrows and Carter. And that is essentially, and in addition to that, Mr Harawira, any such video surveillance evidence has to satisfy a test of reasonableness. In short, any evidence that comes before the court as a result of video surveillance still has to be considered by the courts pursuant to Section 21 of the Bill of Rights Act. New Zealanders still have that fundamental protection. It has not been altered in any way by this legislation. So what we're doing today, Mr Speaker, is allowing video surveillance on private land pursuant to a warrant. Such a warrant has to be granted judicially. And that's what it allows. Then that evidence gained has to be tested as to whether it was reasonably gained. And in that case, the courts will be applying the Bill of Rights Act, Section 21. And there is substantial law on that issue as to what constitutes a reasonable search. And so in that sense, Mr Speaker, the bill proposed does not change the requirement for a reasonable search pursuant to Section 21 of the Bill of Rights Act. And can I say, Mr Speaker, that ultimately is actually the key issue in this bill. Under this bill, any video evidence will be assessed by the courts. They will apply a test of reasonableness to it, whether gained in the future or in the past. They will apply the Bill of Rights protections. That is why, in fact, there is no Bill of Rights statement by the Solicitor General, because it actually meets the Bill of Rights tests. The Bill of Rights still fully applies to any video surveillance evidence gathered pursuant this legislation. And that is an extremely important point that members of this House, and actually more importantly perhaps, members of the public should understand, that they have all of their protections and all of those issues will be raised by them and their counsel in the various courts. Mr Speaker, can I say this also? The Attorney General has taken substantial trouble to get this bill right. Members of the House will know that the bill presented today is different to what was proposed a few days ago. We have ensured, in short, that lawfulness is the test and that reasonableness still continues pursuant to the Bill of Rights Act. And can I say to members on the other side of the House, that fundamental protection has been preserved by this legislation, and that is something that the Select Committee will need to analyse carefully.
I call the honourable member Nanaya